Bonjour, good afternoon. Je vous remercie de vous joindre à moi aujourd'hui à l'occasion de ma 3e conférence de presse annuelle. Lorsque je suis devenu juge en chef il y a 2 ans et demi, je me suis engagé à tenir cet événement annuel afin de faire le point avec vous sur les travaux de la Cour et de répondre à vos questions. Vous pouvez être certain que je suis très heureux d'être en mesure de le faire alors même que nous sommes aux prises avec une pandémie mondiale. Things are very different today than when we last met a year ago. The pandemic has fundamentally changed our society and the way we interact with each other. Some of that might be permanent. It has forced courts to look at different ways of working and accelerate steps toward modernization that were long overdue. Courts have been prioritizing the most urgent cases and using electronic and remote methods to hear cases and continue to deliver justice. But even with all hands on deck, with court staff and judges working all out across the country, the consequences will be lasting. At the Supreme Court, like many courts, we have made a number of practical changes. We moved to video conference hearings for the cases we heard last week. While we have had the capacity for counsel to appear by video conference for 35 years, last week was the first time ever that we had all participants, including judges, online. We even allowed members of the public to register as virtual observers, although, as always, people could simply watch the hearing live on our website. All of this has been an adjustment, but one made easier thanks to the hard work of our staff and the collaboration of parties and counsel across the country. From the bench, the process of hearing from and interacting with counsel is almost as natural as it would be in the courtroom. And aside from a few glitches, which are always be expected when you try something new for the first time, I think it was a resounding success. Yet, we are fortunate. As complicated as the process is, the Supreme Court of Canada is an appellate court, Canada's top appellate court. We hear fewer cases than other courts do. We don't hear from witnesses. We have access to technology and expertise that other courts may not, due to resource constraints. We need to ensure that all courts can continue to deliver justice to Canadians, which is our duty as the judiciary. Together with the Minister of Justice, the Honorable David Lametti, I established an action committee comprised of experts in the justice system, public health, and workplace safety. It's an action committee in the true sense of the word. The members of the action committee, which include 3 other chief justices, in addition to myself, have identified the challenges of jury trials and hearings in small courtrooms, circuit courts, and remote courts as our immediate focus. We are also looking at the longer-term effects the pandemic will have on our justice system and how we can address those. And we are taking the opportunity to start the conversation about long-standing issues that we can improve for the future. Our justice system was not prepared for a pandemic emergency, and as a result, many things immediately came to a halt. Courthouses were closed. Trials were postponed. The Minister of Justice and I knew the system had to keep working, but that we had to do it safely, protecting the health and safety of all participants. I was a lawyer for 25 years and presided over countless trials, including jury trials as a judge. Last year, I said at this press conference that it was time to start taking action for justice. As Chief Justice, I cannot do much directly, but I can use my experience to propose and discuss practical and pragmatic solutions with stakeholders. At the very least, we have to make sure that the problem of delay, which was so chronic before, does not get substantially worse. And let me be clear, to do nothing would be irresponsible. These are not simple challenges, and there are no simple solutions. But we have some of the best minds in the country working on these problems, not just through our Action Committee, but also through the Canadian Bar Association, the Advocate Society, and others. All stakeholders in the justice system have a responsibility to contribute to solutions. I'm confident the changes we make will make our justice system more resilient and more efficient in the years to come. J'ai déjà dit que les juges n'habitent pas des tours d'ivoire et que nous faisons partie intégrante de la société dans laquelle nous vivons. Nous ne saurions accomplir notre travail sans être très attentifs à ce qui se passe dans le monde qui nous entoure. Cependant, en tant que juges, nous devons demeurer indépendants et impartiaux. Nous nous exprimons principalement par les jugements que nous rendons. Au cours des dernières semaines, nous avons toutes et tous été témoins de scènes montrant des gens partout dans le monde qui dénoncent la discrimination raciale et la violence raciale. Il est bon et nécessaire de lutter contre l'injustice, quel que soit l'endroit où elle se manifeste ou la forme qu'elle prend. Au Canada, l'article 15 de la Charte des droits et libertés garantit à toute personne le droit à la même protection et au même bénéfice de la loi, indépendamment de toute discrimination, notamment la discrimination fondée sur la race. Malheureusement, comme on l'a fait remarquer, la Cour suprême, cette garantie n'a pas toujours été respectée. Il y a à peine un an, dans l'arrêt Lee, la Cour a fait état de très nombreux travaux de recherche démontrant les effets pernicieux qu'a le profilage racial sur les communautés racialisées au Canada. Elle a souligné que les personnes appartenant à ces communautés sont l'objet d'un nombre disproportionné de contacts avec la police et le système de justice pénale, et qu'elles sont davantage susceptibles de subir des violations de leurs droits, de se faire blesser ou tuer à la suite d'interactions avec la police. Ces constatations n'ont rien d'agréable, mais il s'agit de faits concrets. Nous savons aussi que les collectivités autochtones sont depuis longtemps victimes de stéréotypes, de préjugés et de discrimination, comme l'a d'ailleurs bien documenté la Commission de vérité et réconciliation. La Cour suprême du Canada a pris acte de ce fait dans le dossier dans l'arrêt Barton. Dans cette affaire, en raison de l'usage de stéréotypes dégradants à l'égard d'une femme autochtone, un accusé a dû être jugé de nouveau. Dans l'arrêt Ewart, dont j'ai écrit les motifs pour la Cour a expliqué à quel point la discrimination systémique dont sont victimes les détenus autochtones a des conséquences plus néfastes pour ceux-ci. Par exemple, le fait qu'ils sont moins susceptibles de bénéficier d'une mise en liberté anticipée. Toutes ces affaires permettent de constater de quelle façon les préjugés raciaux et la discrimination raciale entraînent clairement des résultats injustes. I have said many times that all Canadians should be able to see themselves reflected in their justice system. Justice should not make a person feel like an outsider or an other when they confront it. Judges sitting on a bench in Canada today whatever their background, care deeply about delivering justice to all Canadians, and make great efforts to understand all aspects of the legal issues they confront. This includes racial context, implicit bias, and systemic challenges. Organizations like the Canadian Judicial Council and the National Judicial Institute, which I am very proud to chair, provide guidance and education for judges in this country. This is a priority, and we have created a number of excellent programs and resources to help with this. I also think there is a growing awareness of the need for our courts, including our highest court, to reflect the diversity of Canadians. I certainly would welcome the insights and perspectives this could bring. The last year has been a busy one for the court. Last July, the Minister of Justice and I signed an accord aimed at recognizing and reinforcing the court's independence. The accord sets out the relationship between the Chief Justice and the Minister of Justice and furthers important goals of clarity and openness. I would also mention that in December, the court delivered an important decision on administrative law. The court recognized that this area of law was unclear and in some cases unworkable. My colleagues and I decided it was time to look at it again and chose 3 cases on 2 different issues to allow us to come up with a new approach. Our new framework, set out in Vavilov, changed the way courts look at administrative decisions, with the goal of making the law clearer and more predictable. This will increase access to justice by helping people better understand how our courts will look at the administrative decisions that affect them. Comme vous le savez, l'accès à la justice est une question qui me tient à cœur. C'est pourquoi j'ai décidé, avec l'appui de mes collègues, que la Cour suprême se déplacerait à Winnipeg l'automne dernier et que pour la toute première fois de son histoire, elle entendrait des causes à l'extérieur d'Ottawa. Au total, nous nous sommes adressés à des milliers d'élèves du secondaire et à des centaines d'étudiants et étudiantes en droit. Nous avons également rencontré des membres de groupes autochtones, de la communauté francophone et du milieu juridique. Mes collègues et moi avons participé à une période de questions et réponses ainsi qu'à une rencontre informelle avec des membres du public au Musée canadien pour les droits de la personne. Nous espérons renouveler l'expérience dans une autre ville en 2022. L'accès à la justice est la raison pour laquelle nous publions notre rétrospective annuelle, dont j'ai une copie ici, qui peut être consultée sur le site web de la Cour. C'est également pourquoi nous publions la cause en bref, de courts résumés qui sont rédigés dans un langage simple, qui vise à expliquer comment et pourquoi nous sommes arrivés à telle ou telle décision. Je considère d'ailleurs l'accès à la justice comme un fil conducteur entre, d'une part, les mesures d'adaptation prises par le système de justice pour répondre à la pandémie, et d'autre part, les efforts qui s'imposent pour moderniser le système de justice en profondeur. Nous traversons indubitablement des temps difficiles. Cependant, une période de crise peut souvent, et doit être même, l'occasion de véritables changements. J'espère que de tels changements surviendront et que je pourrai vous en parler l'an prochain. Mais pour l'instant, je suis disposé à répondre à quelques-unes de vos questions. Merci de votre attention.
Nous allons maintenant passer aux questions, commençant par les questions dans la salle. J'inviterai les journalistes à se rendre aux 2 microphones sur pied. We'll now take questions. Beginning with questions in the room, we'll ask reporters to go to the 2 freestanding microphones on either side of the room. Thank you. First question, Dale?
Hi, Dale Smith with the CBA National Magazine. Your comments last week on changes to the criminal justice system, I'm wondering if you can explain those a little more, particularly because there's perception that it puts you in a bit of a conflict because those kinds of changes need to be made by the government, and whether you see yourself as making them, or how in your role as Chief Justice you were making those recommendations.
Thank you very much for your question. We've decided, both myself and the Justice Minister, Mr. Lametti, to set up this action committee with a view to make sure that the justice system would continue to work properly given this pandemic crisis. And so we set up this committee with other Chief Justices in Canada and with health public officials and experts with a view to find ways to make sure that we could continue to deliver justice, given that, for instance, the courthouse across the country had to be closed, that the jury trials suddenly, all the jury trials in Canada were stopped and postponed, and the new ones are not yet on their way. So it was urgent, and that's why we both decided to chair this committee. And the purpose of this committee is, of course, to set up some guidelines, some tip sheets, to make sure that we could, across the country, provide some guidelines to help the courts, lawyers, the stakeholders of the justice system to continue and to start the trials in Canada. Everybody agreed that the most urgent task was to look at the jury trial problem, because by definition, to have 12 people united in one room to hear evidence was problematic. How to choose the jurors, how do you adduce the evidence, and so on and so forth. So everybody agreed that the jury trials was our first priority. And we worked on guidelines, which will be published very, very soon. And at the same time, we discussed ideas on issues that could help in the long run, could help to improve the justice system. We have, many of those ideas come from judges, lawyers, experts in that field. And they are on the table, they are discussed, and eventually could lead to some amendments to the criminal code if Parliament decides to do it. But at the end of the day, that's up to Parliament to decide those issues. But I think it was a right opportunity, given the emergency, given the opportunity to review our justice system, to discuss those issues. And it's only discussion. And I think it's a good thing because, the justice system in Canada, just like anywhere in the world, in society where the rule of law governs the society, the justice system was deficient even before the pandemic crisis. You will recall that we issued a decision in Jordan in 2016 because of the extreme delays to hold a jury trial for the accused. And that was an alarm to the governments, to the stakeholders. And after the release of our decision, governments started to invest in the justice system. But the justice system was the parent pauvre of society for so many years. But now we're not looking at only investment in money. We're not looking for appointments of new judges. We're not looking for constructions of new courthouses. We're looking to modernize the justice system. We should take this opportunity right now, because of this terrible pandemic, take this opportunity not only to remedy the problems of the justice system, but to modernize it for the future, on long-term future. So that's the spirit in which we are working right now, and I'm very proud of it. I think it will be very useful for the society.
And as my follow-up, you're talking about modernization, and I just wondering if we could get some comment from you on pushing courts toward going paperless, for example, as a result of this pandemic, and how your own court is doing it as well as other courts across the country.
Yeah, well, I think it's a big part of the solution, I must say, and it varies from courts to courts and depends on the provinces and depends on whether some countries are more advanced than others in that way of proceeding. But obviously, the trend is there, and I think it's a good thing that we look at those new technology to lower the cost to render judgment and also to increase the safety of holding trials in Canada. Of course, at the Supreme Court of Canada, we don't, as I mentioned, we don't hear witnesses. We have lawyers arguing their cases. There's no evidence that is adduced before the court. The real challenge, I would say, even though we had to adapt ourselves, and we did, we had our own visio hearing last week, and it was a real success. But the real challenge is for the trial courts. It's where the witnesses are coming to the court. That's where the judge has to appreciate credibility on testimonies. That's where experts are heard by the court. And that's where also are held the jury trials. I come back to that idea because it's the most pressing topic, because everything has been stopped so far. And we don't want to see ourselves back to where we were before the pandemic, even though it was still already difficult in those days. So we want to avoid that. So we have to find ways to facilitate the holding of those jury trials. And there are many ways to do it. First of all, we have to find a good way to make it safe. In other words, to have proper guidelines across the country so that those trials could proceed, and also find new ways based essentially, but not exclusively, but essentially on the new technology. To use technology to see if it's not possible to bring or adduce evidence by video, without the necessity of having the person present in the courthouse, in the courtroom, to provide this evidence. I think things can be done. There are other avenues as well for jury trials. For instance, some people suggested that maybe we should give more discretion to the presiding judge when he realized that in one district, the courtroom cannot accommodate a jury trial because it's too small, because to choose a jury, it takes a few hundred people to choose from. Well, that judge could decide to transfer the trial to another district where there is a courtroom, there is a courthouse that could accommodate. But now it's more difficult because you need the consent of the parties. And so those are the type of amendments to the criminal code that could be considered by Parliament. That's up to Parliament to decide those issues. But it's on the table, and it was discussed. And there are other type of initiatives as well that could be advanced. So I think it's the right time to be proactive. It's the right time to try new things, and not simply to find immediate remedy to an existing crisis, but think also at the same time for the longer term.
So we're short in time, so I'll go ahead and ask Olivia for a question. But
Good afternoon, Chief Justice Wagner. Thank you for your time this afternoon. I want to go back to your role on the Action Committee. Do you see how you could potentially be in a conflict of interest by being on this committee, which is looking at suggesting criminal code changes, since these very amendments could face a charter challenge, which the Supreme Court of Canada could end up adjudicating?
Not at all. I think it would be irresponsible not to talk about those potential changes, not to see and discuss the ways to improve our justice system. It is our responsibility to do it at this time. And I don't see any problem, because those solutions, those suggestions, those ideas are shared by many people. And it's not only mine. I don't take the ownership of those proposals. Those are the same thing as, when I suggested that reform should be done and should be made to the CJC, for instance. Reform should be made to the judicial conduct at the CJC. That's proposal, but that's suggestions, but it's up to Parliament to decide at the end and to adopt new legislation if need be. So it's the same for the justice system. But I think we're all in the same boat. And I think that we must ensure that the system will work immediately and also on the long run. So I see no harm in discussing potential solutions.
How can you ensure that Black people and Indigenous people aren't negatively affected by any potential changes to jury trials, since they are overrepresented in the criminal justice system? And more broadly, I'm just wondering if I can pick up on your comment about diversity and whether you think the government should waive the bilingual requirement for an Indigenous Supreme Court justice, or if there should be some other sort of move to make that happen.
Well, there are many issues in your question, and let me say that in Canada, the judges, the various courts, and the Supreme Court, of course, has the obligation and the duty to make sure that the provisions of the Charter of Rights be applied. And when a case is brought to us, because we can only decide things if the case is brought to us. When the case is brought to us, we can make sure that, as a matter of fact, the court can recognize that there are or there were violations and can provide the proper remedy when the court recognizes there is such violations. But we don't work in a vacuum. We're not elected officials. We're not the government. We are judges, and judges will work and will speak through their judgments. So when cases of violations are brought before the court, we will decide and will provide the remedy. As for the diversity, I've been saying that for many years now. I think it's a good thing. I think it's essential that all Canadians recognize themselves in their own institutions. It's good for the court, but it's good for something else, for any other institution as well, but for the court in particular. And that's why I would welcome very well that we apply that principle into the court. But again, with respect, it's up to the elected officials, it's up to the government to make the appointments, and that's their responsibility.
We'll now go to 2 questions on the phone. Operator, do we have a first question?
Thank you, merci. Please press star 1 at this time if you have a question. S'il vous plaît, appuyez sur étoile 1 maintenant pour poser une question. And our first question is from Jim Bronskill from the Canadian Press. Please go ahead.
Hello, Chief Justice. You mentioned that the court system, the justice system in Canada was not prepared for a pandemic. It suggests that the culture of the system is not as nimble as it might be. Are you confident that it can adapt to the new realities, particularly given the already clogged court system and the efforts to expedite justice?
Well, thank you for your question. I think that I am optimistic. I am optimistic because, as you mentioned, the system was very problematic even before the pandemic crisis. There were too many delays. It was costly. People could not afford to hire lawyers, and all those circumstances indicated that serious reforms had to be made. Now, following our decision in Jordan, governments decided to invest and seriously invest in the justice system, but it's not enough. Now that we have this crisis, I think that's the signal to go one step further and to change the way we look at the way justice should be rendered. In other words, we should be willing to consider new initiatives, which was not the case before. It's always comfortable to stay with the status quo, something that we know, something that was decided by somebody else before us. But that's not the way to improve. That's not the way to be progressive. We have to find new ways. And I think because of this crisis, I think that people are ready to do that. That's the result of my conversations with many stakeholders throughout the country, whether it be judges, lawyers, experts, law professors, or civil servants. I think the time has come, and I think the people are ready to consider new initiatives. That will require, however, that people are ready to change their way or their expectation. In other words, maybe people should not always expect to be present physically in a courthouse to convince themselves that justice will be rendered, provided that the most basic principles are upheld, like open court principle, judicial independence, and those type of principles. As long as those principles are respected, I think that people will understand that it would be in the best interest of all citizens that we find new ways to render justice to be more efficient, less costly, safer in a way also. And I think the time has come. And there are many people thinking about the ways to do that. So that's why I'm very confident and I'm very optimistic. But we have to participate in the debate. We have to participate in this exercise. The worst thing that somebody could do is to say, well, I'm satisfied with the status quo. It's dangerous to find new ways of improving the system. I'm not participating. I think everybody should participate in this process, starting with the lawyers, defense lawyers, crown attorneys, civil servants, judges.
Follow-up?
What do governments need to do in that process, particularly with regard to funding and making sure these things happen, or changing rules as well?
Well, I will let the government officials answer your question. I'm sure that they will have more information than I have, because they are the one who have to take this responsibility. But I can appreciate, like any other citizens, that government can act through legislation, government can act through regulations, they can act in many ways. So I'm pretty sure that they would be able to do their part.
Opératrice, prochaine question.
Merci. La prochaine question, the next question is from Kristen Schmitz from the Lawyers Daily. Please go ahead.
Good afternoon, Chief Justice. Thank you for coming.
Hi, Kristen.
I have two questions, well, one question and a follow-up. One is that in a webinar, you mentioned that Quebec had abolished the civil jury system. And I wanted to ask you, however, other provinces have not, and certainly many lawyers are not keen in those provinces to see the civil jury system abolished. I wanted to ask you what you think. What advantages are there to abolishing the civil jury system? What have you seen?
Well, you know, the civil jury system was abolished in 1976 or 1978, if I remember, in the province of Quebec. And I started to practice law in 1980. So I never experienced the positive sides or the negative sides of having a civil jury. So I have no opinion on the good and bad sides of this institution, and it would not be proper for me to comment on that.
Okay, and my follow-up, Chief Justice, once the pandemic is over, you've mentioned that you think that the remote hearings at the Supreme Court went very well last week. Would the court, or is the court, considering having remote hearings on a permanent basis, maybe on an optional basis? And what advantages and disadvantages would you see to this?
That's a very good question, Kristen, because you're right. We had to do it, we did it, and we enjoyed it. So the question is, to what extent we should not implement it for the future on a permanent basis. But there are many issues that need to be discussed. before going to that conclusion. There are expectations of the parties, the lawyers, in terms of organization, to make sure that we could do it on a permanent basis. It's one thing to do it for a few days, a few weeks, but it may be a different thing to do it on a permanent basis. But I'm pretty sure that it will be discussed within the next few weeks. We have cases scheduled for the end of September. We have the carbon tax case at the end of September, and another case dealing with the jurisdiction of the Quebec Court and the Superior Court. We put that at the end of September in the hope that we could hold these hearings in person, because there are many interveners and many lawyers present. So it may be a bit too difficult to preside such hearing by visio or remotely. So our people, our staff, our personnel at the Supreme Court are looking right now at different options. Should it be impossible to hold these hearings in person, there will be another option, and we are looking to that other option. So we are following, of course, the guidelines of the public health authorities, and we will adapt according to those guidelines. But it's an idea that is there for the future. I'm pretty sure that even the lawyers and some clients would look favorably to those remote hearings in the future, not only in terms of safety, but in terms of cost as well. So I think it is there to stay in one form or another.
Thank you.
Nous allons...
En goût des solutions qui feront partie des discussions de ce qui sera évalué.
Bon, c'est une question très vaste et la réponse le serait tout autant, dans la mesure où présentement, il y a plusieurs groupes, en raison de la pandémie, il y a plusieurs groupes qui s'intéressent et qui étudient les solutions à apporter aux problèmes immédiats, de telle sorte qu'on puisse continuer ou reprendre l'activité judiciaire comme elle l'était avant la pandémie, puis également pour étudier, justement, comme je le mentionnais tantôt, à des moyens pour prendre l'opportunité de cette situation-là, pour améliorer et changer le système judiciaire. Et je parlais évidemment de notre comité avec le ministre de la Justice. On travaille fort avec l'aide d'experts, de consultants et de conseillers et de juges et d'avocats à élaborer des directives qui vont permettre, si elles peuvent être appliquées dans chacune des provinces, permettre la continuation et même la reprise de certains procès, et notamment les procès par jury, qui sont les procès les plus difficiles à reprendre à cause de la nature du processus. Mais au-delà de ça, ça a amené également d'autres groupes. Je pense au Barreau canadien, qui a un comité d'action aussi là-dessus, de réflexion. L'Advocate Society a mis sur pied un comité d'action également pour étudier la façon avec laquelle, dorénavant, la société canadienne pourra concevoir le système de justice. Alors, vous voyez que ça a une portée très large. Ce n'est pas simplement une question immédiate de remédier immédiatement aux problèmes causés par la pandémie, mais de prendre l'opportunité de regarder à long terme. Et toutes les options sont sur la table, mais évidemment, toutes les options passent, la plupart, par l'usage des nouvelles technologies. Alors, pour mettre un frein à l'usage du papier, par exemple, nous, à la Cour suprême, on a déjà amorcé le mouvement, puis je mets beaucoup d'emphase là-dessus avec l'aide de notre personnel pour éliminer le papier. Et je pense qu'il y a plusieurs autres tribunaux à travers le pays qui vont dans le même sens. Alors, les nouvelles technologies seront la voie du futur pour procéder à ces changements de fond au niveau de la tenue des procès, au niveau de l'administration de la justice. Et sûrement que ça devra entraîner aussi des amendements de structure, donc des amendements aux lois fondamentales, soit les codes de procédure civile dans les différentes provinces, pour s'ajuster aux nouvelles technologies, puis également au code criminel aussi au niveau fédéral, pour s'ajuster aux nouveaux besoins qui seraient créés par ces nouvelles technologies-là. ce sont des amendements qui demanderont évidemment de la réflexion, qui vont demander des consultations, qui vont demander des échanges avec les groupes traditionnels impliqués dans le domaine, les avocats, les juges, etc. Et donc, ces amendements-là arriveront, mais peut-être un petit peu plus tard dans le processus de réflexion et de révision de notre système de justice, je pense.
Suivi?
Je vous remercie.
Impératrice, prochaine question.
Merci. The next question is from Elizabeth Raymer from King Media International. Please go ahead.
Good afternoon, Chief Justice.
Good afternoon.
Thank you for talking to. Good afternoon. Thanks for talking to us today. I had two more, specific questions. The first was if you had any sense of when jury trials might resume, and second, if you could elaborate on any anticipated changes to how jury trials are conducted. I think a while ago you had mentioned possibly holding them in hotels, that type of thing, and also possibly reducing the number of jurors, at least on a temporary basis. So are you able to expand on that now?
Well, I will be able to expand a bit more tomorrow. I have a meeting with the Justice Minister tomorrow regarding our committee, and there will be guidelines that will be issued within the next few days. But I would prefer to do it with the Justice Minister to expand on the nature of those guidelines by respect. And those guidelines will be very helpful and will be used by the various courts, trial division across the country to properly start the jury trials in a safe way, while, of course, upholding our main fundamental rights in criminal matters. Those are fundamental. But so that's why I believe that the jury trials will be able to resume pretty soon. You mentioned one of the problems to hold jury trial, and that's why they were stopped back in March, is that to start a jury trial, you have to call for hundreds of people to be selected as jurors, if only for that reason. So where do you put these people if you have to keep some distance between individual and all the safety issues and so on and so forth? So and once the jury is completed, how do you do to have 12 people seated one beside the other and receiving and hearing case? I mean, so it's not safe and it's not proper, and so I'm pretty sure that we'll be able to give some very useful guidelines on those issues. And for the other ones, which would call maybe for changes in the legislation, it's up to government, it's up to Parliament to decide when they would even consider making those changes. But it's part of the overall, examination or review of our criminal system.
Follow-up?
No follow-up. Thank you, Chief Justice.
Thank you.
Take two more questions in the room.
I'm wondering, do you believe there is systemic racism in the justice system, and how high of a priority should that be when justice actors are already overburdened?
Well, I could only tell you that we decide those issues when the cases are brought to us. And I think that it's up to the elected officials or other people to make broad statements, generally speaking. We judges, we speak through our judgments in cases where we have facts. And if you look at our jurisprudence, and I refer in my statement to some cases that we've decided for the last couple of years, in which we recognize, because there was evidence brought before us, we recognize that there was some discrimination and that people, all Canadians, have the right to receive equal treatment under the law. We have Section 15 of the Charter of Rights, and the courts are there to uphold those provisions. And when we see that there is discrimination, when we see that there is systemic discrimination, like in the case of Ewart. I would invite you to read the reasons in Ewart. We came to the conclusion that there was a systemic discrimination for the Indigenous people inmate in that situation. So in those circumstances, I can refer to Barton and Lee. In those circumstances, when the evidence was adduced before us, before the lower courts, we recognize, we denounce it, and we provide the proper remedy.
I'm just trying to sort it out with some clarity. You know, with respect, you've pointed out issues in the criminal code. This is a yes or no question that a lot of heads of institutions are being asked, and I'm just curious if you could explain your reluctance to give a yes or no answer on systemic racism in the justice system.
I'm not reluctant. I'm only acting according to my duty, and my duty as a judge and a chief justice is to decide cases upon the evidence that is brought to us.
Wanda?
Good afternoon, Chief Justice. I just want to follow up on that, but your duty also is as Chief Justice of Canada to speak on behalf of the institution, the judicial system. And so I think the questions that we're trying to probe, given your comments about, you mentioned systemic bias, you mentioned racial context, and you mentioned how you try to train judges to recognize the racial context of cases. But I think the question for you is, in the largely white justice system of this country, is there a systemic racial bias that impacts Blacks, Indigenous, and people of color who come before the courts? In other words, are your judges subject to systemic racist bias?
Well, I can only tell you, Tanda, that as judges, we decided and we recognize in cases where that evidence was put forward, if there was such discrimination, such bias, or such systemic discrimination. But we don't issue broad statements generally without having a case to be decided upon. And that's why I think that we should provide our best efforts given those very important issues. We have to provide our best efforts to give to our judges, so to give to our justice system the best training possible on those issues. And I am very proud to tell you that through NGI, National Judicial Institute, we set up some extremely good education and training courses and sessions that are given to judges all across Canada on those issues, to recognize when there is bias, to recognize what it is, systemic discrimination, and to be able to respond to those needs. And I think that in that line, I think that our judiciary is well trained. I think that the worst thing that we should do is to think that those issues only concern other countries and not ours. I think that we have demonstrated in our cases, in our jurisprudence, that our society have not lived up all the time to the standards of our Charter of Rights.
Do you have a follow-up?
And so just then I think, is it possible for you to say whether, how you feel about the lack of representation on the bench, broadly speaking, in this country, of Black, Indigenous, and people of color actually sitting in the judge's position?
I wish that we would get a more diversity on the bench. No doubt about that. That's something that is welcome. That's something that is good for our society, to make sure that society and all individuals of different origins could recognize themselves into the institutions. And among the important institutions are the courts of law. So I welcome those changes if they could come.
Merci. Thank you. This concludes the press conference. Ceci met fin à la conférence de presse. Merci.
Merci. Bonne fin de journée.